You may not be aware of it, but state after state, anti-gun liberal politicians are doubling down on the thing they like doing the most, proposing assault weapon bans. They typically like to target firearms with certain features like detachable magazines and pistol grips, which these politicians and their left-leaning cohorts believe enhance their lethality. As of last month, 10 states, including California, New York, and Illinois, have implemented such bans, each with varying definitions and restrictions. We are now left waiting on the Supreme Court to clean up the mess. And guess what? 3 major cases are finally on their radar. In this video, we'll talk about the Supreme Court's next move in Snope v. Brown, Ocean State Tactical v. Rhode Island, and Greb v. Jennings, cases that could end assault weapon and magazine bans for good. We'll dive into why Maryland, Rhode Island, and Delaware think they can trample all over people's 2A rights, what the Supreme Court's sudden interest might mean, and why time is running out to resolve these legal disasters. If we don't see a decision soon, it's going to be open season for states to pass even more draconian laws. Stick with me as we unpack the chaos, expose the delays, and show why these cases are make or break for the Second Amendment. By the end of this video, you'll have a solid grasp on what's going on and why you should care. So, grab a seat, make yourself comfortable, and we'll jump right into the action. Let's start by laying out the basics of the 3 main legal battles we're keeping an eye on. The first one is Snope v. Brown, which challenges Maryland's assault weapon ban. This case has been moving through the courts for a while now, and it's basically ready for the Supreme Court's review, except Maryland has taken its sweet time filing responses. Those delays have kept the case in limbo, but it's now at a point where the justices could decide whether to take it on soon. Next, we have Ocean State Tactical v. Rhode Island. While Snope v. Brown focuses on assault weapons, Ocean State Tactical zeroes in on Rhode Island's magazine ban. It's a separate issue, but it has a lot of overlap in terms of the broader debate about how states regulate firearms. Like Snope v. Brown, Ocean State Tactical is fully briefed and waiting to see if the Supreme Court will pick it up. Scheduling has been shuffled around, possibly to align with other cases. The third case is Greb v. Jennings, which targets Delaware's assault weapon ban. This one's a bit different because it centers on the standard courts should use to grant an injunction. It's still in the middle of the legal process, yet the Supreme Court has shown a surprising amount of interest in it. Some people think the court might use Greb v. Jennings to clarify a key procedural question that could also affect the outcome of the other 2 cases. Essentially, all 3 cases are interlinked because they involve the broader question of whether certain kinds of firearms bans can stand under the Second Amendment. That's why a big move in one could influence the fate of the others. So let's talk about what's happened lately with these 3 cases, because there's been some real movement, especially with Greb v. Jennings. A major headline is that the Supreme Court has officially scheduled Greb v. Jennings for conference on January 10, 2025. For those of you who might not know, a Supreme Court conference is basically when the justices meet privately to decide which cases they're going to hear. Most cases that make it to conference never get granted a full hearing, so just getting on the calendar is a big step. Now, here's where it gets interesting. Both Snope v. Brown and Ocean State Tactical v. Rhode Island are also in the pipeline, waiting for the Supreme Court to decide their next steps. Ocean State Tactical was initially ahead of the pack, but then it got rescheduled. Meanwhile, Maryland was taking forever to file its responses in Snope v. Brown, which pushed that timeline back as well. And right when Delaware filed its pleadings in Greb v. Jennings, the attorneys for the plaintiffs waived the usual 14-day waiting period. That allowed the case to jump straight to the conference schedule, and boom, January 10th is now a date we should circle on our calendars. It might sound complicated, but if you connect the dots, you see a pattern. The Supreme Court may be interested in hearing all of these cases around the same time. That opens the door to the possibility of consolidation. In other words, the court could decide, hey, we have 3 cases dealing with assault weapons or magazine bans. Let's bundle them up and address them in one go. That would be a huge development because it would let the justices craft a single, sweeping opinion that could affect every state with similar bans. Another reason this is such a big deal is that the Supreme Court typically doesn't take cases that are only halfway through the lower court process. Yet, they're paying close attention to Greb v. Jennings, which is still dealing with the question of what standard to use when granting an injunction. The fact that they're fast-tracking this conference date suggests they might want to lay down some rules sooner rather than later. You might be wondering, Alright, so the Supreme Court is looking at these lawsuits. Why should I care? The short answer is that these cases could redefine the boundaries of the Second Amendment for decades to come. If the court decides that assault weapon bans or magazine restrictions are unconstitutional, it could strike down similar laws in multiple states. That's not just a win for the folks filing these lawsuits, it's a massive shift in how guns are regulated across the country. Conversely, if the court rules these laws are constitutional, states that have been on the fence might feel empowered to pass even stricter regulations. Right now, the landscape of gun laws in America is a patchwork quilt. Some states have very loose regulations, while others like California, New York, and yes, Maryland, Rhode Island, and Delaware have stricter rules on the books. A Supreme Court ruling that clarifies what's allowed under the Second Amendment will bring some uniformity, but it's going to upset someone no matter how it goes. Another critical point is that these cases could resolve lingering questions from previous landmark decisions. Since the Supreme Court's Bruin decision in 2022, lower courts have struggled to figure out the exact test for judging Second Amendment cases. Are we only looking at text, history, and tradition? Are we balancing government interests? How do we measure public safety concerns against individual rights? Greb v. Jennings, in particular, could set a new precedent for when courts should pause enforcement of a law while the lawsuit is ongoing. That might sound narrow, but in practice, it's huge because it decides if these bans stay in effect or get suspended as the case winds its way through the courts. Finally, for gun owners, these legal battles touch on fundamental questions of personal freedom and self-defense. If you live in a state considering a ban or already enforcing one, the outcome could directly affect what firearms you're legally allowed to own. So whether you're just following the daily news or you're deeply invested in Second Amendment advocacy, these cases are definitely ones to watch. So let's look ahead. The Supreme Court conference for Greb v. Jennings is slated for January 10, 2025. At that conference, the justices could decide to grant review, deny review, or even hold the case over until they see what happens with Snope v. Brown and Ocean State Tactical v. Rhode Island. If they grant review, it means they've decided the case is worth a full hearing, which would include written briefs, oral arguments, and eventually a published opinion that sets legal precedent. Meanwhile, we're keeping our eyes peeled for any sign that Snope v. Brown and Ocean State Tactical v. Rhode Island might also get scheduled for that same conference date or a nearby one. If all three line up, the court could combine them into one big showdown, giving us a definitive ruling on everything from injunction standards to whether assault weapon bans violate the Second Amendment. That's every legal nerd's dream. A single sweeping judgment that might settle the debate once and for all, or at least for the foreseeable future. Of course, the justices could decide not to hear any of these cases this term. If that happens, we'd likely be waiting until at least October 2025 for another chance. That's where a sense of urgency comes in. Time is ticking, and the longer these cases hang in legal limbo, the more states might enact or enforce similar bans. For instance, if other states see no immediate Supreme Court action, they might feel more confident passing their own restrictions, figuring they can always sort it out in court later. On the flip side, if the court moves quickly, we could get a major Second Amendment ruling before the term ends in late June or early July of 2025. That would not only resolve these specific lawsuits, but also serve as a blueprint for future cases. Either way, January's conference is a pivotal moment. It might be the first domino to fall in a series of events that will shape the legal landscape for guns in America. One big reason we care about timing is that the Supreme Court's docket is already packed. They only take a limited number of cases each term, and they usually wrap up major opinions by the end of June or early July. If these cases don't get heard in the coming months, we're looking at a delay that pushes us into the next term, starting in October 2025. That's a long time for these bans to remain in place if they're not paused by an injunction, and for people to wonder what's legal and what's not. Another issue is potential shifts in the court's makeup. Justices can retire and new justices can be appointed. While there's no guarantee that will happen anytime soon, it's always a possibility. A single retirement or appointment could tilt the ideological balance of the court. For a hot-button issue like gun rights, that might change the outcome entirely. So the longer these cases hang around, the more likely we'll see external factors start to weigh in on what should be a purely legal question. Also, from a practical standpoint, gun owners and manufacturers are in a state of uncertainty. Should they comply with bans that might be struck down? Should they wait to see if new laws are passed? People deserve clear answers about what they can and can't own or sell. That's why getting these cases settled sooner rather than later is in everyone's best interest, regardless of where you stand on the ideological spectrum. If you want to keep tabs on these cases yourself, I highly recommend you follow organizations like the Firearms Policy Coalition, the GOA, or the NRA, as they'll likely provide updates on any major developments. For those who really want to be in the loop, consider signing up for docket alerts, which let you know the moment a new document or order appears. In the meantime, let's talk about this down in the comments. What do you think about these bans? I think they're very likely going to be struck down, but who knows? What are the chances of the Supreme Court upholding them? How do you see the justices voting if these cases make it past conference? Share your thoughts below because your perspective matters. Whether you're a 2A advocate, someone who supports tighter restrictions, or simply an onlooker who finds the legal drama interesting. If you found this video helpful or insightful, hit that like button, consider subscribing, and share it with friends who might want to know what's going on. Your support helps this channel grow and keeps the conversation rolling. Thanks for watching, and God bless America.